Hey everybody, how's it going? And welcome back to Copper Jacket TV. So I am extremely excited to talk to you guys today about a major victory that just happened moments ago at the time I'm making this video, where a circuit court has once again held that a federal ban is unconstitutional. This one is big, so let's go ahead and talk about it. Hey, real quick, if you guys are watching this video and you have not yet subscribed, consider hitting that subscribe button. It's free, it only takes a second, but it really does help us out here a lot. It helps us spread our message, and it lets the powers that be know that you guys want to see content like this, which helps us stick around for a little while longer. So thank you to everybody who has subscribed up until this point. Let's go ahead and get to it. Okay, so let's go ahead and talk about what's going on here. So this is thanks to the FBC and the 2AF in a case called Reese v. ATF. This is a case that challenged the federal ban on 18 to 20-year-olds purchasing handguns. As you guys, I'm sure, are well aware, you can't do that until you're 21 under federal law. Well, the Fifth Circuit Court of Appeals has said that, under Bruin, that is 100% unconstitutional. So let's talk about what the details are and what this means for the country in various states. So this case obviously started at the district court level, and at the district court level, we didn't get the decision that we wanted. So it ended up being appealed to the Fifth Circuit Court of Appeals. We can take a look at a document here which shows exactly what the complaint is. Now, on appeal to the Fifth Circuit, the plaintiffs wrote in this introduction, the Second Amendment right to possess and carry weapons in case of confrontation presumptively belongs to all Americans and not unspecified subsects. On their 18th birthdays, the individuals in this case became legal adults for almost all purposes, and certainly for the purpose of exercising their other constitutional rights. They're entitled to vote, enter contracts, get married, they can join the military and fight and die for their country, and as adults, there are no parents or legal guardians generally responsible for their care and protection. Yet the laws and regulations challenged in this case, the ban, categorically bar them from accessing the commercial market for handguns, the most preferred firearm in the nation to keep and use for protection of one's home and family. And that's a quote from McDonald. Now, they also explained to the Fifth Circuit why the district court got it wrong, and they absolutely got it wrong. It says the district court dismissed plaintiffs' claims holding that the handgun ban was constitutional because there existed a historical tradition of similar firearms regulations that satisfied the requirements of the tests laid out in the NYSRPA v. Bruin. The district court was wrong to reach that conclusion because at the founding, the most relevant time period for understanding the scope of the Second Amendment, there were no restrictions on the rights of 18 to 20-year-olds to keep and bear arms on account of their age. Indeed, people in that group were, by dint of being in the militia, actually required to acquire firearms. And as for later laws on which the district court relied, they're unable to bear weight in the district court, bear the weight the district court places on them. They come too late in time, they did not restrict the rights of legal adults, and many of them were the sorts of laws that Bruin disregarded entirely. There is simply no historical regulation from any relevant time period. This is relevant time period that this is anything like the handgun ban. The decision below should be reversed, and this court should direct that the judgment be entered for the plaintiff's favor, or in the plaintiff's favor, excuse me. Now, to you and I, this pretty much seems open and shut. It seems fairly simple. I mean, if you just follow the test in Bruin and go back to the ratification of the Second Amendment in 1791, there is no relevant historical tradition of any type of firearms regulation like this. As a matter of fact, it was encouraged, and in some cases, it was law that you had to have something on hand just in case you were called up to the militia. So again, this is extremely important to the nation's history and tradition of this type of regulation. It just didn't exist throughout that time period. And so for us, it's fairly easy to see that this should be an absolute win. However, there was a case by the NRA that went to the Fifth Circuit previously where they said, nope, we believe that this is constitutional. It was basically the same type of challenge, and they upheld it as being constitutional, but that was before Bruin. So now after Bruin, it's brought back to the Fifth Circuit, and the Fifth Circuit writes this. Now, this comes directly from the Fifth Circuit's order from earlier today, where it says, conclusion, ultimately, the text of the Second Amendment includes 18 to 20-year-old individuals among quote-unquote the people, whose right to keep and bear arms is protected. The federal government has presented scant evidence that 18 to 20-year-olds' firearms rights during the founding era were restricted in a similar manner to the contemporary federal handgun purchase ban, and its 19th century evidence cannot provide much insight into the meaning of the Second Amendment when it contradicts earlier evidence. In some, federal regulations and their attendant regulations are unconstitutional in light of our nation's historic tradition of firearms regulation. We reverse the district court's judgment, and remand for further proceedings consistent with this opinion. So the Fifth Circuit Court of Appeals has officially said that that federal ban is unconstitutional, and they reversed and remanded it back down to the district court for further proceedings based on the opinion of the Fifth Circuit. So the Fifth Circuit is basically telling the lower court, look, you guys got it wrong. This is unconstitutional, and you need to fix things. And so that's basically where this stands now. Because the district court has to follow the precedent of the Fifth Circuit Court, and the Fifth Circuit Court has said that this is unconstitutional, the district court really has no other choice now but to say, in fact, this is unconstitutional based on Fifth Circuit precedent. So this is extremely important and huge news. Now, here's where the big test comes in for the new administration, okay? I'm sure you guys have seen all of the confirmation hearings for all of the new heads of the three-letter agencies. It's up to those three-letter agencies to decide whether or not they want to continue on with this challenge. So under the previous administration, we could almost be assured that this would get appealed probably all the way up to the Supreme Court. But under this new administration and under the heads of these new officials who run these agencies, if they determine that they just don't want to pursue it anymore, they don't have to appeal. If there's nothing that's written out that says if you lose, you have to appeal, it has to go up to a higher court. No, they can decide not to pursue this anymore and just let the court's opinion speak, and that would be the end of it. So for me, this is really the first real test of the heads of departments for these new agencies and what they're going to do. I mean, whether they're going to back up all their big talk and what they said during their confirmation hearings or didn't say. But this is the big test for that new administration. Do you let the court speak and say, look, it's unconstitutional and let it go? Or do they continue to appeal it and maybe it goes all the way up to the Supreme Court? The thing is, I don't think the Fifth Circuit, I can almost guarantee you that the Fifth Circuit would take this again. If for some reason they, let's say that the district court says, yeah, it's unconstitutional, right? And the three-letter agencies decide, well, we're going to appeal it up to the final decision up to the Fifth Circuit. The Fifth Circuit's already spoken on this. That's over. So that would be the end of it there. The only way that they could go any higher than that would be if they appealed that to the Supreme Court. And so it's up to those agencies to determine what they want to do at that point. So this is a big test for the new administration in my mind, obviously. But definitely a ban that I am excited to see an appellate court call unconstitutional, because it absolutely clearly is. Anyway, I wanted to share that with you guys today. I really appreciate it. Please like, subscribe, and you guys have a great day.